Only mode.
Hello, everybody. Welcome to today's webinar. It's straight up almost 11 o'clock, so we'll go ahead and get started. It's my pleasure to introduce Sarah Benson, who is the copyright librarian at the University of Illinois Library, who is going to talk to you today about authors' rights. If you have questions, you can type them into the questions box on your control panel. We also, depending on how many people we have actually attend the webinar, I may just unmute you all and let you ask questions when the presentation is over. So, and we can have some discussion. So with that, Sarah, I'll turn it over to you.
All right, thanks a lot. Hi, everybody. Good morning. I hope you're not too cold. It's a little frosty out here. My name is Sarah Benson. I'm the interim head of the Scholarly Commons and the copyright librarian at the University of Illinois Library. I'm coming to you today from my study. I would have loved to have done this in person, but we'll have to make do. I will be trying to keep this a little interactive, so if you have your chat open, that would be great. And I'm probably going to turn my camera off just so we can all focus on the slides, but I wanted to show you I'm a real person. I really do exist. And yeah, that's about all I wanted to say about that. All right, so let's get started. I can move my slides. Okay, so my first thing is I always give a disclaimer because I am a lawyer. I have a law degree from the University of Houston and a master's of law from the University of California at Berkeley. But in my role as copyright librarian, I'm here to provide legal information and access to resources, but not legal advice. So sometimes when people come to me in my role as copyright librarian, I actually have to refer them to a lawyer because although I am a lawyer myself, I am not employed as one from the university. Sometimes I also work with general counsel's office. So if it's something that they could address, I refer them there, but often it might be something that's outside of that realm and they end up going to a lawyer outside counsel. So you are all scholars of some sort at the university. How many of you own a copyright? I see we've got about 14 people in the room. You can post it in the chat like yes or no, or I don't know, or maybe, or something. Let's see. Anyone? Oh, I'm seeing in the question box. Not sure, don't know. Someone says yes on my dissertation. A lot of don't know, don't think so. Okay. Well, actually, it's a little bit of a trick question because the reality is that you all do, and you probably own multiple copyrights. Why? Because copyright is actually super easy to have. So all you need are two things to own a copyright. You need something that is minimally creative, or what we call original. So it doesn't have to be a work of fine art, right? It can be a note, a letter that I wrote, a photograph that I took. It could be notes that I took for class. It could be my syllabus. It could be an actual paper, a research paper. All of those things you own a copyright in. So again, you probably own lots of copyrights. And then you just have to fixate. There's the requirement of fixation, which is it has to be written down or recorded. It can't just be something, an idea in your head, for instance. But that's all you need. As long as it's something that's copyrightable and it's minimally creative and written down or recorded, you have a copyright. And the length is a long time. It's generally the life of the author plus 70 years after you die. So for anything I create right now, which I'm writing a book, I'm writing a few articles, the copyright on that is going to last for the rest of my life, plus 70 years after I die. So God forbid if I drop dead today, 70 years after this, and at the end of the calendar year, it's always the end of the calendar year, even though it's January right now, It would be the end of that calendar year, and then whatever I had would enter the public domain. And even when I transfer my copyright, because often, like I'm writing a book right now for a publisher, the publisher is actually going to own the copyright in that, but they can only own it as long as I would have owned it, if that makes sense. So it's still going to be calculated on the basis of my lifespan, if that makes sense. So anyway, long story short, that's, you all own a bunch of copyrights. You might have transferred some of them, right? If you publish things or you have books or things, or journal articles, you might not own those anymore. But if you're working on some other paper, then you would own that. So what does copyright protect? Because obviously it doesn't protect everything. It protects a lot of stuff though, a lot of stuff that we do for the university, right? It protects writing. So all those scholarly articles, all of the teaching materials that we create, all of the notes, if we have scholarly notes and things, all of those things are protected in copyright. Choreography for dance, music and written music, you know, the scores, visual art, film, and architectural works, right? The things that it doesn't protect, like I said, were ideas. They have to be written down, and they can't be genres, right? They can't be so broad as to be like a scène-affaire or a genre. Facts are not protectable, so I can't own like the date of the World War or something like that. Names, titles, slogans, or short phrases like Nike's "Just Do It," that's just too short a phrase to be owned in copyright. It might be trademarked, right? Because "Just Do It" is a trademark of Nike, but it's not protected in copyright. So there are three branches of intellectual property, of course. You've got trademark, patent, and copyright. And today we're only talking about copyright. There are other things in intellectual property that we're not talking about, so just bear that in mind. Data generally is considered fact, but the arrangement and compilation of data may have a thin layer of copyright. If anyone works with data, we can talk about that some more. And then useful articles, like I said, that's patent. So, you know, inventions, that would be patent, and we're not talking about that. And Steve asked a question, do these belong to us at U of I, or if they're completed as part of our jobs? Good question, and I'm going to talk about that a little bit later, so hang on to that question, because that's a really great question, right? All right, so what rights do you have in copyright? You have the right of reproduction, or to make copies of the work. You have the right to distribute the work, or make sales of the work, or even put it on the internet, right? One of the common misconceptions about copyright is everything on the internet is copyright free because they've waived copyright. That's not true, because that's one of their exclusive rights, is the right to distribute the work. And then the right to create derivatives of the work, right? So if you think about a new volume or a new edition of a work, that is the right of the copyright owner. And then the right to publicly perform the work and the right to publicly display the work. And those mostly come into play for creative works, right? Like movies or songs or theater. And all of these things together, all of these rights together, the reproduction, distribution, derivative, public performance, public display, these are what we call the bundle of rights. So if you hear someone talking about the bundle of rights, they're talking about these rights. They are all automatic, right? That you have as the copyright owner. Of course, you have the right to license any of the above to third parties, or all of the above, right? And as the author, when you enter into publishing agreements, that's what you're going to have to do. You're going to have to grant some sort of license, or else the publisher cannot publish the work. So who owns the copyright? Of course, the author does originally, but if the author is not just one person, then it might be a joint work, right? And the default under the Copyright Act is that joint authors have an equal, undivided interest in the whole work, as long as they intended to create it together as a joint work, right? So if you're working with multiple authors and you don't intend it to be a joint work, you might want to have an author's agreement about who owns what. It's never a bad idea to get that in writing and to kind of agree to that so that you don't have any misunderstanding. The other thing is, and there's this big but here, right? Who is the author? The people who've created the work, except for work made for hire, then the employer owns the work. Now, what is a work made for hire? It's a work where you are paid by an employer, you're hired, right? And you're paid for, with Social Security benefits, right? And you have a 9-to-5 job, and as part of your employment, you create this work. That's a lot of stuff, right? And at the university, that would be all of our work, right? I'm hired. In order to get tenure, I have to create these works, and then I'm going to publish them or whatever to get tenure. And so they're created in the course of my employment. Now, interestingly, the university gifts back as a gift all of my copyrights to me as a faculty member. So the University of Illinois Board of Trustees does not want to own all of my copyrights, okay? They decided, that's not a good idea, especially if Sarah Benson is teaching, like this PowerPoint, for instance. I use it for teaching as a faculty member. And so I own this copyright because the University Board of Trustees says that anything I use for teaching or for research, I own it. Now, here's the thing. Right, if you're not faculty, I know that you're not faculty, because I asked beforehand, are you APs, are you faculty? So if you're not faculty, the university still owns your work. Why? Because again, that was just a line that was drawn in the sand in the university statutes. So academic professionals, for works that are created in the course of your employment for the university, they are actually owned by the Board of Trustees. And that is just a line, like I said, that was drawn in the sand in the general statutes. So it's important to know that. Why? Because if you want to publish something, let me take an example. If I want to publish something, I can just go and I can go ahead and enter into an agreement with the publisher, and I don't have to involve the university at all. But if you are an academic professional and you're going to publish something, then you might need to check a box that says who owns the copyright. If there's a box where you can say the university owns it, you have to check that box. And then you might need to follow up with the Office of Technical Services because they're the ones who kind of deal with the university owned copyrights. Okay, so it's a little more complicated because you don't necessarily own it yourself. Right, so I think I answered that question because there was a question, what about those of us who are APs and faculty? Well, that's confusing. If you're APs and faculty, then I think it depends on which hat you're wearing, if that makes sense, right? So if you're creating something in your day-to-day job as an AP, the university would own that. But if you're, like, say, an adjunct faculty member and you're creating teaching materials for that class, then you might own that stuff. So you're going to have to kind of separate what you're doing, if that makes sense. All right, so I hope I've answered most of those questions. Let's keep going. So why do we worry about copyright? Well, we want to protect our work from infringement, right? We don't want people stealing our work. Or maybe on the reverse side, we want to make our work as easy to access as possible through open access. I'm a big proponent of open access. I use Creative Commons licenses on a lot of my work. I like to publish open access because actually it's a lot easier for people to see the work and to cite the work. And I actually might get more citations for my open access work. So a journal that doesn't have a paywall and allows freely licensed works is kind of a good thing, right? Because if you do have a paywall in the journal, then you're only communicating to folks who can afford that journal subscription, right? Instead of everyone. Okay, so if you do want to protect your copyright, let's say you're not trying to publish open access, you would use the copyright symbol, right? So you would put something like copyright Sarah R. Benson 2021. Okay, I just put that in the chat. That copyright symbol doesn't look completely right. It's not closed because of the chat functions, but That's what you would do. It's that simple. You would put it on the bottom of the first page, and it would put other people on notice that you own the copyright. It is not required, though, to own a copyright. Remember, I told you the only thing that you need to own a copyright today is to create the work, is to write it down and record it, right? But a lot of people don't know that. And it seems like right in this room, when I asked, like, how many of you own a copyright? A lot of you didn't know that. And so a lot of other people don't know that. And so it's a good idea to put that on there because other people are also confused about copyright. Now, of course, if you're an AP, you would put copyright University of Illinois Board of Trustees 2021, right? That would be who owns it, not you. If you created it in the scope of your employment, that's where you would put that. Now, you cannot recover damages for infringement, however, until you've actually filed for or registered a copyright with the U.S. Copyright Office. So a lot of folks think, I don't own a copyright because I never, contacted the U.S. Copyright Office and registered my work and paid like the $95 filing fee. That's not true. You still own it, but you can't sue anyone for copyright infringement until you register it. So let's say I have this PowerPoint and I own it and someone steals it and I'm really mad and I tell them, stop using this, that's my copyright. And they say, so sue me. And I say, oh no, I can't sue them because I didn't register it. Well, I can go and register it that very day and recover damages going forward. So it doesn't mean, it's not a good idea to do things that way, right? And book publishers never do. They register it right away upon publication because you reserve higher damages if you register it quickly, right? The damages that are called statutory damages, that are those like big damages. So it's a good idea to register your work quickly if you think you're going to sue someone or going to need to sue someone, but it doesn't mean you're waiving your right to sue. It just means you can't sue them until you actually file the registration. Someone asked a question, how about as a student, if you're writing papers for projects? That's a really great question because I didn't address that in my earlier slide about who's the author. And the university also gives students back their copyrights. So just like faculty own their own copyrights, so do the students. So the students are less like APs and more like faculty in the eyes of the university. So the students own their own like dissertation, they own their own thesis, right? They have to give the university a copy of it so that we can prove that they've met their qualifications, but they own the copyright. Good question. All right. Or, of course, the last thing you could do is you could put a copyright symbol and a Creative Commons license if you want to make your work open access with some restrictions. So if I wanted to make my work a Creative Commons work, then I might say copyright Sarah R. Benson 2021, and then CC BY 4.0 or something like that. That means that I own the copyright, but I'm giving everyone a license to use it as long as they abide by that Creative Commons license. And if you're unfamiliar with Creative Commons licenses, you can go to creativecommons.org and check it out. Anyone can use it. It's like a license between one and many. So instead of a license between me and, say, a publisher, a one-to-one license, it's a license between me and everybody in society saying, here's how you can use my work without having to ask me for permission first. And if I use CC BY, what I'm saying is, as long as you cite it with like proper academic attribution, say my name, say the title and where you got it, then you can do whatever you'd like with it. And this is the license that I actually use on my syllabus. Why? Because if anybody asks me for my syllabus, I'm automatically going to tell them, sure, borrow it, do what you want, right? And so instead of having to answer all those questions, can I use your syllabus? Can I use your syllabus, right? I just put that on there so that people know they can use it. I do that on my library guides as well, because again, when people ask me, I always tell them go ahead. So this way, as long as they cite it, they know that they can use it automatically. So it's good for everybody. This one final note about Creative Commons licenses though, is that they are irrevocable. So you don't want to willy-nilly put a Creative Commons license on something if you later might change your mind, right? Because if I'm going to one day use my syllabus and try to sell it in a book or something, and I've already put a CC BY license on it, I can't take that license off. So it's important to think carefully about the things that you want to put a Creative Commons license on, because once you put that license on there, you're stuck with it. And the reason for that is that people rely on those licenses, right? People see it and they say, oh, I can use this in this way. And so we need to be thoughtful about using them. But Creative Commons is a really great resource for authors, and it's a great resource if you're trying to use other people's work, because you can search for specific licenses through the Creative Commons and find a variety of resources that way. Okay, let's move to the next slide, because we've been on that slide for a while. Sorry, I got a little sidetracked. All right, so by university policy, you means faculty, right? Retain your copyright for research articles, not APs, as we discussed earlier. But by agreement with the Faculty Senate, all faculty members agree to a non-exclusive license with the University of Illinois to publish their articles openly, and they can do so through IDEALS, which is our institutional repository. But also any person at the university who's doing research and wants to make their work openly available can use IDEALS. So this applies to APs as well if you want to make your work available through IDEALS and preserve your work. So what to do with that research article? Well, you can share it in the institutional repository. You can also put work in there that is for teaching or posters or things like that. You still own the work, but it gives others a way to access it because it's an open access repository. So there's no paywall, and it's called the Illinois Digital Environment for Access to Learning and Scholarship. So again, it includes educational materials, and you can find it at ideals.illinois.edu. And it gives IDEALS a non-exclusive license to publish the work. We'll talk about that in a moment, what that means. And then there's the Illinois Data Bank. So if you have data that underlies your research that you also want to make open and also to preserve it, this is a really good place to put it in the data bank. So you can put it at databank.illinois.edu. And the data bank and IDEALS will communicate. So if you have like an article and all the data underlying the article is in the data bank, then they'll link. So if someone goes to your article in IDEALS, they'll see the link to the data in the data bank. So it's a really nice way for people to find not only your research, but your data as well. So most of the stuff is freely available. There are options to embargo the material. I've had to do that before because I had a publication that the publisher said, you can put this in your institutional repository, but only after 6 months. Because in that way they say, well, we want to make our money off of it first, basically. That's fine, and you can say when you want it released openly. But the point of IDEALS is to make the university work broadly and quickly available to maximize impact. So we're basically just trying to get our research out into the world, right? If you saw with the COVID-19 research, a lot of paywalls were waived, right? A lot of news articles, if they were dealing with COVID, you could see them, whether you subscribed to that journal, subscribed to that newspaper or not. And that's the idea of IDEALS, right? It's that you don't need to subscribe or pay money. We just want people to see what we are producing at the university because it's good for society. And here's more information about the data bank, and it can be linked to your other related materials, like I said, such as articles, any file or format up to 15 gigabytes can be temporarily embargoed, and they will preserve it for a minimum of 5 years, and then at that point they will reassess it because of just space issues. but they'll let you know if it has to come down. So here's where I want some interaction again with the audience. So what do you, if you write a research article, what do you want to use it for? What is the purpose of writing that article? What are you going to do with it? Okay, so someone says communicate it to the public. That's great. Publish it. Yes. What else might you do with it? Oh yeah, you might need it. You might need it for grants, to share it with your grant organization. You might share it with other researchers, share with non-subscribers. Yeah, all of these things. So I wrote down a few things, like you might want to share it with colleagues. You might want to make it available to the public, your ideals. You might want to use parts of it yourself in future work, right? Derivative works. You might want to post it on the internet. You might want to prepare a textbook. You might want to share it in a presentation at a conference, right? All of these things. However, we know that we have these exclusive rights and copyright automatically upon creating our work, but as soon as we contract it away with a publisher, we no longer own the copyright if we give the publisher the copyright. So we need to negotiate with the publisher to allow us to retain some rights. Now, if they'll allow us to retain all of our rights, the copyright, the full copyright, that's great. That's the best case scenario. But at the minimum, we want to ask them to allow us to retain rights to put our journal article in the institutional repository, or to use it to teach, or to use it for certain things, right? Or if we're a grad student, we want them to allow us to use it in our dissertation, right? We don't want to be banned from using that work that we're publishing as part of a chapter in our dissertation. Then we can't use it in our dissertation. That's kind of counterintuitive, right? So, hocus pocus, you are now a lawyer. If you sign this agreement, what rights do you retain? So it says copyright transfer. In consideration of the action of the publisher in reviewing and editing this submission, I hereby transfer, assign, or otherwise convey all copyright ownership, including any and all rights incidental thereto, exclusively to the publisher in the event that such work is published. How many rights do you retain there? Yeah, those of you who are saying, oh, someone says the right to use the raw data. I don't think so, though, because it says all rights incidental thereto, which would include the data. Although if you're saying raw data that's not even copyrightable, maybe, right? Yes, I see that point. That's a good point, because raw data is not copyrightable, but even the arrangement and compilation of the data has a small copyright on it, so they might even own that. But the general gist of it is that you've transferred everything to that publisher. And you would not believe how many folks just sign that with no problem, right? They're just like, okay, I'm getting published, I'm excited, I'm going to sign this. Read this carefully, right? Because it says you convey copyright exclusively to the publisher, and that's the key word here, is exclusively, right? So you don't retain much, right? What about this one? Author's retention of rights. Notwithstanding any terms in the publication agreement to the contrary, author retains 1, the rights to reproduce, distribute, to publicly perform, and publicly display the article in any medium for non-commercial purposes. 2, the right to prepare derivative works from the article. And 3, the right to authorize others to make any non-commercial use of the article, so long as the author receives credit and the journal in which the article has been published is cited. So how many rights do you retain here? necessarily all copyright, but a lot, right? A lot, because you're retaining the right to reproduce it for non-commercial purposes. Not all copyright, because copyright would also include commercial purposes, right? But this is a lot. This is a lot of the stuff that we want to do with it, right? I mean, most of the time, I'm not trying to sell my work. I'm trying to use it for educational purposes, derivative works, allow other people to use it, right? All of those things. Right, the right to use it in future publications and conferences. So this is one of those things that you can tack on as an addendum to a regular, like, exclusive copyright transfer and say, but I retain all these rights. And that's a nice thing to do, right? Because now the publisher, you know, you don't have to ask them every time you want to use it, or other people want to use it. And I don't know how many of you have had this happen where someone emails you as the author and says, hey, can I use this work in X? And my response generally is, I don't own that work, right? The publisher owns it. Or have you emailed an author and said, can I use this in X? Well, and if they say, sure, go ahead, they're probably lying to you. I mean, not intentionally, but they don't know that they don't own it anymore, right? I mean, the publisher owns it. So unless they have this kind of addendum, and they may, right? More and more authors' agreements are including this type of language by default because a lot of authors are demanding it. But you have to read those authors' agreements, right? Because if you don't know what you have. All right, so even more practice. Here's another license. By accepting this license, you grant to the university the non-exclusive right to reproduce and distribute the submission, including the abstract, in any format or medium worldwide and royalty-free, including but not limited to publication over the internet. So what do you retain when you sign this license? Yeah, so you retain the copyright, right? I mean, this does not transfer copyright. It says the non-exclusive right. So you are giving the university the right to reproduce the work through, and this is actually the exact license from Ideals, from our institutional repository, right? This is the exact wording of that license. It's basically saying, hey, we have the right to reproduce this work and to maintain the work, but you still own it. So this is a good license. It's not scary. It sounds scary because it's a lot of legalese, right? And it says things like any format or medium worldwide, right? And it just sounds scary, but it's not scary because the key word here is non-exclusive. Those are the kinds of licenses you want, non-exclusive rather than exclusive, right? And I see someone asked in the chat, how do we get these rights? I don't think there's a box to check. Good question, because what makes me really annoyed, I don't know about you, but what makes me really annoyed is click-through licensing for journal articles, right? Where they say, oh, congratulations, you are going to get published. Now click accept and you accept this license. That's not good because that does not allow for negotiation. And so in those instances, what I usually do is I email the publisher and I say, hey, you know, I am really excited about this publication opportunity. However, I would like to talk about the publication agreement, and it's a click-through thing right now, but I want to add this addendum. Please get me in touch with whomever can help me with that. And sometimes they will, and sometimes they will just say, you accept it or you don't, right? You either click accept or or we're not publishing it. I mean, that is true of any negotiation, right? You go to negotiate for a used car and they say it's $20,000, and you say, how about 15 and throw in some tires? And they say, nope, it's $20,000 cash, that's it. So sometimes the negotiation works and sometimes the negotiation doesn't work. But even if it's a click-through license, which is harder, I agree, to negotiate, you can still ask if they're willing to do it another way, like not with a click through. Okay, we're not going to do this part, but okay. So here, the good news is you don't have to reinvent the wheel. You can use what's called the Spark Author Addendum, and here's the link to it. And it's very similar to the language that I used in that example where it was the good example of retaining a bunch of rights. And so you can download that and say to the publisher, hey, I would like to add this addendum to the contract, and have them sign it. And then you would be able to keep your copyright, or at least some of the copyrights, right? Another good link that I wanted to share, and I just posted it in the chat, is this right now we've been talking mostly about journals, but if you are negotiating a book contract, it's kind of a whole nother world. Generally speaking, authors do not retain their copyright when publishing a book. It's much harder to do, but there's a lot of stuff you can negotiate. And when I negotiated my own book contract, I used this guide quite a lot. It's very thorough, it's very good, and it's open access, so anyone can access it. So I really encourage you to take a look at that if you're negotiating book contracts, and I'm also happy to look at any sticking points if you need somebody, a fresh pair of eyes. Okay, so all of this begs the question that you own so many copyrights, but don't others own copyrights too? Yes. And you know, what if it's on the internet? Does that just waive the copyright? We already answered no. And how can I legally use the work of others when I teach or do my work, right? Or just do general work for the university? So we're going to talk a little bit about what isn't protected by copyright. So copyright, as I said, lasts a very long time. Life of the author plus 70 years after they die. And because it's so easy to get a copyright, it's basically automatic, and it lasts for so long, there's a lot of ways to poke holes in copyright. Unlike patents, for instance, which is very hard to get a patent, and then it only lasts a short period of time, like 10 years. So it's very hard to pierce through a patent, but very easy to pierce through copyright. So the first thing is to know which works have fallen into the public domain. So works published in the United States before 1926 are in the public domain. That's a moving target. It's going to be before 1927 next year on January 1st, 2022. Now, you're probably saying, Sarah, I'm confused. You said that life of the author plus 70 years is the term of copyright. That's true. But copyright law is not static. It has changed over time, and the law from the 1920s is different from the law today. And the law in the 1920s said that copyright lasts as long as the date of publication plus 95 years. So if you do some basic math and you add 1925 plus 95 equals, oops, that doesn't look right. So 1925 plus 95 equals what? 2020. Now, that means that at the end of 2020 or January 1st, 2021, because remember I said copyright ends at the end of the calendar year, January 1st, 2021, everything from 1925 entered the public domain. Now, remember, this is anything published. There's a keyword there, published, in the United States before 1926. So that includes movies, music, works of art, books. Again, they have to have been published. And that's important. That's an important distinction. But if it was, it's in the public domain. For instance, The Great Gatsby fell into the public domain this year. So that's really exciting. What else is in the public domain? Works produced by the US government within the scope of their duties. So for instance, all case law and all statutes are in the public domain. Again, because it was created by the US government in the scope of their employment. Kind of like a work made for hire, just what we were talking about earlier. All right, so there's also a copyright exception for teaching. Section 110(1) for face-to-face teaching, and it permits the display or performance of any work for face-to-face classroom use as long as the material was obtained from a lawful source. This doesn't really help us today because we're not face-to-face. Most of us are teaching online, or at least partially online. But back in the day, I could show a full-length Disney movie without worrying about it because that's a performance or display of the work in face-to-face classroom experience, right? Now, it doesn't say copies. So I'm not allowed to copy an entire textbook, right, and give it to my students. It's a display or performance in face-to-face teaching. So today, when teaching and doing other things, we're more in the realm of fair use. And I know some folks were interested in hearing about fair use. It's volume 17 of the United States Code, section 107. And in the preamble or the introduction, it says, the fair use of a copyrighted work for purposes such as criticism, comment, teaching, including multiple copies for classroom use, scholarship or research is not an infringement of copyright. So most of what we do at the university is teaching, scholarship, or research. So that is squarely within the purpose of fair use. But fair use does not end there, and it's always evaluated on a case-by-case basis. So in determining fair use, we've been told that the factors to be considered shall include the purpose and character of the use, including whether such use is for nonprofit educational purposes, the nature of the copyrighted work, the amount and substantiality of the portion used, and the effect of the use on the potential market or value of the copyrighted work. So all of these things must be weighed. And it's case by case. So let's say I have a PowerPoint with 5 images. I have to do a fair use analysis for each image. I can't just say, let me evaluate the whole PowerPoint. That's not really how it works. So let's go through the factors, and I hope you appreciate my copyright humor. Sorry about, I abbreviated fair use FU because it's funny. So on the right, that is more likely to be fair use. On the left, it's less likely to be fair use. So the more educational or nonprofit the use, the more likely it is to be fair use. The more commercial, the less likely it is to be fair use. So most of what we do at the university for factor 1 weighs in favor of fair use. Another thing that we consider is transformative use. So I call this factor 1+ because it stems out of the first factor, but it's a judge-made rule. And the court said a transformative use is one that alters the original work with new expression, meaning, or message. So if you've changed the work and now it means something different, it's more likely to be a fair use. So then courts look at the nature of the work. This is actually the least important factor, and courts don't really care about it that much, but they have to look at it. And so if it's unpublished or highly creative, it's less likely to be fair use. But if it's published and factual, it's more likely to be fair use. And then of course, the amount and substantiality used. If you can't copy an entire book, it's not a fair use. The heart of the work is the most important part of the work. So if there's like a refrain in the song, for instance, that might not be a fair use versus a small amount, right? So one of the examples that I use when I teach this to students is a block quotation. So let's say you're writing a paper and you need to quote a book for 100 words, which is a block quotation, right? It's 50 words or more. And inside the cover of the book, it says, no part of this book may be reproduced without express permission of the publisher. So do you call up the publisher and say, can I quote this, 100 words from this book in my paper? I'm sure you don't, but why not? Put it in the questions or the chat. Why don't you call the publisher and ask for permission for a block quotation in an article? Yeah, so someone just hit the nail on the head. It's a fair use, right? I mean, students get very confused because they start saying, well, I don't know, it's not plagiarism. And I said, yeah, it's not plagiarism, but that's not copyright, right? Copyright and plagiarism are two different things. Plagiarism is an academic norm. Copyright is a law, right? You violate copyright, you can be sued. It's not that you're going to get a bad grade, but you can certainly insert that block quotation, especially if you're using it for what? Criticism and comment, educational purpose. It's a small portion used, all of those things, right? All of those things make it a fair use. And the students' eyes get really wide and I say, guess what? You've been applying fair use your whole academic career. Since you were in middle school, you were probably using block quotations. You just didn't know it. You just didn't know that it was a fair use. So someone in the chat says, however, students cannot just insert a picture from a textbook in their dissertation. The answer to that is actually, it depends. Because if they're really using and analyzing that picture and it's essential to their argument, it might be transformative, right? If they're like telling why the picture is important and analyzing it, as opposed to using it for decorative purposes, right? The more transformative something is, the more you comment on it, the more courts would find it to be a fair use. So it depends. And it also depends if they plan to publish that dissertation, right? Because some publishers are more comfortable with fair use and others are not. So even if the university would say, oh, it's fine, it's a fair use because this is nonprofit, once you get into a publication, the publisher might say, well, no, we're actually selling this journal, right? And so now the first factor has changed. It has changed into being commercial. And the last factor has changed, right? We are potentially replacing the marketplace for that work, right? So it really varies on the purpose for which you're using it and what the output is going to be. But of course, the more transformative the work, the less likely you are going to impact the market value. I'll give you an example. So I'm writing a thesis about women from Harry Potter, and I have to quote Harry Potter all over the place, right? Quote Hermione and all this stuff. Well, I'm not replacing the marketplace for Harry Potter, right? No one wants to read my thesis as a bedtime story, you know, because it's entertaining. It's not entertaining, right? It's not going to replace the market value. So it is transformative and fair use. So it really very much depends. And the question is, do I need to get permission to copy a figure from a thesis in my publication? Again, it probably depends, right? It depends on what you're doing with the figure and, you know, whether your publisher would even be okay with fair use. One thing about figures is they're usually based on fact. And if you can just grab the facts out of it and create your own figure, then you might be okay, right? Because the facts are not copyrightable anyways. All right, so there's a really great fair use checklist that I recommend if folks are a little bit still confused about fair use, and you can keep it on file, which is great. Why would you want to keep it on file? Because if you have a good faith assessment of fair use, then you are protecting yourself from big damages, because under the Copyright Act, we in our employment as educators and employees of a nonprofit educational institution are protected against statutory damages as long as we had a good faith belief our use was a fair use. So if you document it, that might document your good faith belief. So that's a good idea. Also, I want to raise everyone's awareness to the fact that the CASE Act just passed with our last budget, which is a small claims court for copyright, and it's going to take effect in about a year. I just want to raise your awareness because those statutory damages might not be there, but the small claims court people can sue for up to $30,000, which is crazy. I don't really support the small claims court, but key provision is that you can always opt out of the small claims court, and it's a good idea to do it. Why? Because it's expensive for someone to file suit in a federal court, right? And so they're going to have less incentive to keep pursuing the claim. So if someone sends you a demand letter in 2 years and says, I'm going to take you to small claims court, but if you don't pay me, you know, $2,000, you can just say, well, I'm going to opt out. I'm going to opt out of small claims court, and I'll see you in federal court, right? And I had a good faith belief this was fair use, and I have my fair use checklist right here, right? And they are going to have a lot less incentive than to do anything about it. So just letting you know. Link to the fair use checklist. Yes. I need to figure out, I have so many windows going on. Hang on.
I'm just going to break in right now and say that I'm keeping track of links, and all of this, including the recording, will be going up on the survey, the different survey library LibGuides, and I'll send you I'll send a link out to that when it's available. But all those links, I'll pull all the links together for everybody. So
here's a link. There it is. I found it. Okay. Somebody says, if you cite used material, does that not cover possible fair use issues? Not necessarily, because again, plagiarism and fair use are different. And courts in analyzing fair use do see citation as helpful, right? Because it's a way of saying, like, I acknowledge this isn't mine, I'm citing it. And you should cite it anyway, right, for plagiarism issues. But it doesn't necessarily mean that you're covered for fair use, if that makes sense. It's just one of the possible things that they consider. I do recommend citing for multiple reasons, but it's not necessarily the be-all, end-all for fair use. Okay. Let me see if I can get to the next slide. Oops. Aha. Are you guys still seeing my slide that says or ask for permission? I hope so.
yeah, you're good.
Okay, good. So if all else fails and you can't find something with a Creative Commons license on it, you don't think it's fair use, it's not in the public domain, there's no copyright exception that applies, you can always ask for permission. You would locate the copyright owner first. I always recommend starting with the publisher, not the author, because usually the publisher is the one who owns it. Of course, this means it's not published OA, because that would just have a Creative Commons license on it. You would ask in writing whether you can use the item, and be sure to indicate the purpose if it's scholarly research or something like that, because hopefully they wouldn't charge you a big fee for that. And there's a page on Columbia Copyright Office's website that deals with asking for permission. I'm looking for the link right now. Well, I'll have to find it later. Anyway, there's a page there that has a good sample letter that you can use, but there's no, like, it doesn't have to be an exact thing. You just need to get permission in writing. An email counts as writing, and you would want to get, you know, a non-exclusive license to use the work for whatever purpose. You just have to explain what the purpose is. And also, of course, if you're confused, if you're like, this was too much, I'm very confused, or I still don't know enough about fair use, help, you can always call me or you can email me. I'm putting my email in the chat. I'm always happy to talk to folks. Oh, thanks, Steve. Steve just shared the Columbia permissions page. And I also have a handy video explaining fair use that you can watch. It's only, I think it's like 6 to 8 minutes. So if you forget or you want more information about transformative fair use, feel free to go to that video. I also have a lot of library guides. If you go to the library website and search for copyright, you'll find a bunch of library guides that would remind you about things we talked about today. But I'm always here. I'm here to talk through issues. That's my job, right? So don't feel bad contacting me. I'm happy to chat with people. Here's my email address, some attributions. And of course, I really value feedback. Oh, no one can see the permissions one? Okay, hang on. Nope, that's not it.
Again, I'm pulling all these links together, and they'll go up. They'll be permanently available on the on your associated survey library guide. So, and that link will go out with the email to the video recording, to the recording of the webinar also.
No, I sent it, but I sent it just to Steve somehow.
Okay, oops.
I'm doing fun things here in chat. I don't know. Okay, it's fine. But anyways, I'm always happy to help and talk to folks. Oh, I know what I was saying. Hang on, there it is. Okay. Where's my slide? There it is. Okay. So if you have things you would like to tell me about this presentation, like, hey, I really didn't understand X, or can you talk about Y more, or I still have questions about something, feel free to email me a follow-up about this presentation. I value feedback. I want people to understand what I'm talking about. That's the idea, right? So my email is srbenson@illinois.edu, and yeah, I'm happy to answer questions and also just to get feedback. I think we have about 5 minutes. I've answered questions as they've come in. If anyone has any other questions, I'm happy to answer them in the last few minutes here.
Sarah, do you want me to unmute folks?
Sure, if they want to talk, sure.
Okay, I'm going to unmute everybody. So if you have a question, you can ask. And if you don't, that's okay too.
Yes, Sarah, this is BK. Have you talked to any of the publisher to give the rights, the copyrights that you mentioned in your presentation? And if yes, what was their response? I mean, most of the time, I don't think they would like to amend the agreement, but I may be wrong.
My response has been varied. Some publishers have been very open and some have not. So I think it very much depends on who you're talking to, like who the publisher is, right? Like Nature magazine or Nature journal is not going to be very open, I would think, to like any kind of negotiation. But like others are, many, for instance, have it already incorporated into their authors agreements because they've already gotten so many inquiries. So people always say, sometimes people are surprised when they start reading their authors agreements and say, oh, actually my authors agreement is pretty good. So it just depends. I got a question for APs who don't own copyright. Who is authorized to sign a publisher agreement? So often what I've seen is in the agreement, it will say something like, I own the copyright, or I don't own the copyright, it is owned by the Board of Trustees. And if you check that and you still sign it, I think that you are covered because you're noting, like, I don't own this copyright, it's owned by my employer. In cases where the agreement doesn't spell that out, you might reach out to the Office of Tech Services. But for instance, when you want to put a Creative Commons license on something that's owned by the copyright, like say a website or something like that, that's owned by the university, going through the Office of Tech Services is usually the right route. And they'll usually say, oh, it's fine, right? But you're just supposed to contact them. So, but when in doubt, you can ask me and I can put you in contact with the right person. I have her email, we converse a lot. But again, if you click, like, I don't own this, it's owned by the Board of Trustees, that should be fine because they can follow up. The journal will either know, like, oh, this is fine, we've worked with them before, or they'll follow up. Good question. Any other questions? Oh, so one of the questions is it okay to upload papers onto personal web pages and ResearchGate? It depends. So the answer is it depends. It depends on what rights you retained in your copyright, right? When you publish the work. So if you retained the right to upload things to your personal website or institutional repositories or other academic sites, then it's fine. Often, authors are unintentionally violating their copyright agreements with their publisher when they upload to those sites. Because if you didn't have permission from your publisher and you still uploaded, say, the final version, right, the peer-reviewed version, you might be violating your copyright agreement. So you need to read your author's agreement and or negotiate your author's agreement to allow you to do that. Because there have been issues with authors putting works on ResearchGate when they're not allowed to. Good question. Well, I think our time is up, and I am happy to continue the conversation over email. I'm always around and happy to talk about copyright. That's my job. So please feel free to contact me if you have further questions.
Thank you so much, Sarah. This was really informative.
All right, thanks.
I will be sending out a follow-up email. It'll go out tomorrow. It'll have links to all of the links and the recording, and it will also have a link to a survey. So please complete the survey so we can get your feedback on this webinar and then input on topics you might want to learn about in future sessions. Thank you, everybody, for participating today. Have a good rest of the afternoon.